The park was there on Monday. By Thursday, there was a sold sign on the gate. No vote, no public notice. A deed filed in county records 4 months earlier while we were all going about our lives. 112 households, 3 board members, one decision none of us were asked about. Everything I'm about to show you, I found myself, one document at a time. Here's where it started. I moved to Clearwater Crossing 4 years ago after a job transfer. 43, no partner, no kids. I chose this neighborhood partly because of that park. 3 acres of oak trees, a walking trail, 2 benches. I ran it every morning before work. The sold sign appeared on a Tuesday. I assumed a mistake. I emailed the HOA board contact page. No response. I asked my neighbor. She had not heard anything. Nobody had. That was when I started pulling the thread. 20 minutes. That's all it took at the county recorder's office to find the deed, our board president's signature, dated 6 months before any of us noticed the sign. I called the property management office. I got the coordinator. She said the board exercised an emergency authority provision to execute the sale. I said, "What emergency? The park has been there 30 years." She said, "Submit a written inquiry." 7 years. This board president had been sending violation notices for holiday lights left up 2 days too long, signed every email community steward, then sold the thing that held the community together. A paralegal friend walked me through what I was actually looking at on a Sunday afternoon. She said, most HOA governing documents require a supermajority vote to sell common area property. Yours required 60% of all homeowners of record, not just meeting attendees. All of them. I said, that vote never happened. She said, then they used something else to get around it. Did your board cite an emergency clause? An emergency powers clause, built for a burst pipe, a liability issue, not built to authorize the permanent sale of community land to a private developer. She said, there's a second problem. Pull the dates again. The deed is dated March. Is the resolution authorizing it dated before or after? I checked. May. She said they filed the wrong document first. That's not a technicality. That's the whole case. I submitted a formal records request, the emergency resolution, meeting minutes from any session where the sale was discussed, and the identity of the buyer. 8 days later, the resolution only, 2 pages of vague language about fiscal sustainability, everything else denied. I said they refused the rest of the request. She said HOA members have a statutory right to inspect association records, send a follow-up citing the statute by number, certified mail, statute cited, 10 business days. On day 9, a letter from an HOA attorney. The withheld records were protected under attorney-client privilege. Attorney-client privilege. For meeting minutes, I called my friend back. I went to the county recorder's office a second time. The deed was public record. The purchasing entity, Meridian Urban Development LLC, Delaware registered, no local address. Meridian was a subsidiary of a parent company with 14 high-density residential projects in 6 states, every single one replacing green space or community common area. Then I found something else. 12 months before the deed was recorded, our board president's name appeared as registered agent on a consulting LLC. That LLC had received 2 payments from a company sharing a registered address with Meridian. She said, if you can connect those payments to Meridian, this is self-dealing, possibly fraud. I said, how do I prove it? She said, file a complaint with the state attorney general and find an HOA fraud attorney. You don't have to do this part alone anymore. The HOA litigation attorney reviewed everything in one sitting. She said, the deed sequence alone supports injunctive relief. With the self-dealing evidence, we can seek full rescission of the sale. We filed an emergency injunction to halt any construction pending legal review. The night before the hearing, a truck arrived and began clearing brush along the park fence. I filmed it from the sidewalk and texted the footage to my attorney at 11 p.m. She said, do not go near the property. I will use this in the morning. At the hearing, the HOA's attorney argued the sale was valid and that delay would cause financial harm to the developer. The judge asked one question. She said, "Counsel, can you explain why the deed is dated March 14th and the emergency resolution authorizing it is dated May 2nd?" The HOA's attorney asked for a brief recess. Injunction granted. Construction halted. 3 days later, I received a letter from the HOA. I was in violation of the governing documents for circulating unauthorized communications to neighbors, the email chain where I'd shared the county deed with people on my street. $300 fine, threat of a property lien. I said, "They are trying to price me out of this fight." She said, "That is retaliatory action, prohibited by state statute. Send me everything. We're adding a retaliation claim." That same week, the state attorney general confirmed they had opened an inquiry into the consulting payments. Our board president resigned 4 days later. No statement, just gone. Mediation. 6 weeks after the injunction, Meridian agreed to rescind the purchase contract. The payment the board had received was ordered returned to the HOA fund under court supervision. The retaliatory fine against me was reversed. The HOA was required to adopt a new policy requiring a homeowner vote for any future disposition of common area property, no emergency clause exceptions. I stood at the park gate the afternoon the injunction became permanent. My neighbor was there, the woman who had lived in Clearwater Crossing for 19 years and cried when she first saw the sold sign. She said, "I did not think we could actually win this." I said, "Neither did I." She said, "How did you know where to start?" I said, "I pulled the public record. Everything came from that." The deed was public record the entire time. Anyone could have pulled it. It cost nothing. 20 minutes at a county records counter. The board sold that park because they assumed nobody would look. For months, nobody did. HOA governing documents are legally binding on the board, not just on homeowners. Emergency powers clauses cannot override a required supermajority vote, and self-dealing by a board member is fraud. Full your CC&Rs tonight, find the section on common area disposition, find the emergency clause, then check your county recorder's website and verify your common areas are still titled to the association. 20 minutes, free. If something doesn't look right, share this with your neighbors first. Then start the paper trail. The park reopened on a Saturday in October. The oak trees were still standing. Subscribe for real cases and real outcomes every week.